Okay, so we have about 2/3. For those of you that don't know, Wrightslaw is the website that my wife and I, Pam, I need you to stand up for just a moment and give her some recognition. With my wife, Pam, he's the brains behind Wrightslaw and everything that we do, and I'm just the lawyer guy, and that's about it. And we have written a bunch of books. The book that hit me when Marty asked me to talk about preparing for IEP. How do you prepare for IEP? Well, I mean, is this a youngster that has autism, or is this a child with cerebral palsy, or is a child with dyslexia? I mean, how am I going to address this? What am I going to talk with you all about? Because I don't know about a particular factual scenario and the school district. Are they real oppositional, or do they bend over backwards and to provide everything they can? There's so many unknowns. Say, well, now, where do I start? Okay, well, but what I do, you gotta go through the file first. I've got to go through the child's entire file. And as an attorney, when I had an active practice, I'm not practicing active, I'm still licensed, but not practicing actively, or as I'm on the road doing trainings about special ed law. But as an attorney, when I had a consultation with a potential clients, they had to fill out a detailed questionnaire that answered a lot of questions for me. Nature of the disability, what did they want, why did they want this, what was the history of the child, date of birth, etc. And then also provide me with the Bible in chronological order, the oldest document on top, the most recent on the bottom. And so I had the file, and I would go through the file before I would meet with the parent. That way I had much better sense. Because I found that half the time parents were going after the wrong things. They wanted this, and this is what they wanted to fight about. But the issue that I saw was over here. And it was a classic case that I had, and I was talking about yesterday. Youngster James Brody out of North Carolina, Brody versus Dare County, and the mother came in to see me. Her son was in the latter part of the 8th grade, was going to be going up to the high school next year, 9th grade, and he'd had an aide ever since either kindergarten or 1st grade. All along, he had an aide 24/7, the entire time, entire school day. And the high school said, they're not going to give him an aide. They don't do that at high school level. And so she wanted to retain me to force the school to provide him with an aide. And so as I went through the file, I didn't understand why she wanted an aide for him. And I asked her when she came in, well, Mr. Wright, he has dyslexia and he can't read. So the aide reads everything to him off the board. And when the students have their textbooks open, she goes to that page and she reads out loud to him the what's in the textbook. And then when he's got to do a written assignment, written stuff, the aide does all the writing for him. He just dictates to her and he does it all. So the aide reads everything, writes everything for him, does everything for him. But why? Why is the aide doing all that? Because Mr. Wright, he has dyslexia. He has dyslexia and he can't read. That doesn't mean he can't be taught how to read. He can learn how to read if he's taught properly. No, that's right. You don't understand. He has dyslexia. And by definition, it means he cannot read. I said, I don't think you know my own story. DC Public Schools told my parents I was uneducable, mentally retarded, emotionally disturbed, nothing can really be done about it. But bottom line, it was Streptosymboliae, then now known dyslexia, dysgraphia, scapulosis, and ADD. And I had Orton Gillingham 2 years, one-on-one from Diana Hamburger King, who was one of the gurus in the field of Orton Gillingham. So I'm blessed. I have intense early intervention from one of the very best in the history of the Orton Gillingham and of dyslexia. So I am a poster child for top of the line quality early intervention, because I am not your typical adult dyslexic who stumbles over reading. My reading is fast. My writing is fast. All these issues, because I had intensive one-on-one, I went to a residential camp between the 1st and 2nd year she's working with me. So she was telling me he can't read because he has dyslexia and nothing can be done about it. And that was what she truly believed, because that's what they've been telling him year after year after year. And I said, well, no, we don't want to go after an aide. We don't want to force them to provide an aide for him at the high school level. That's not going to help him one bit. That's not going to teach him how to read. We got to get him into a program that does Orton Gillingham
and really makes up for all this lost time. But he's lost so many years. And the nice thing about it in that case was his IQ was above 130. He was a real genius kid, really, really bright. But reading, writing, arithmetic scores, all of them were down at the bottom. He never been taught any skills, any educational achievement skills at all. And so I got comprehensive evaluations of them, private sector evaluations, and we ended up shifting over and going for private placement tuition reimbursement. The mother and the husband, they didn't have a lot of money, but fortunately there was a wealthy aunt who has never given any of the family members any money at all. But when they pled their case to her, she funded the tuition for Landmark School up in Massachusetts. So they got him in a Landmark, and we went after this school after the Dare County School District for tuition reimbursement for Landmark. And we had a due process hearing in North Carolina. At that time was a two-tier state. So party at due process, losing party appeals it to the state for appointment of a review officer, review panel. So we wanted due process, they appealed it, the review officer took the mom's letter requesting due process. It was what we call the letter to the strangers that told the story that a stranger could read and understand, and it hit him in the gut. The review officer took the letter to the stranger, copied and pasted whole verbatim portions of the letter, but never referenced the letter, but copied, including also the typographical errors. There's some spelling errors, and when parents write something like that, typically don't go in there and change it and make it look beautiful at all, make it more real. And so he relied on the letter the parents wrote requesting due process. Again, we call that the letter to the stranger, and there's information on the Wrightslaw website all about that. And referenced that in the training the other day over here. And so we wanted due process, we won it with you, and the school system did not take it into federal court. We were ready for federal court. But what was the neat thing about it also is James Brody sat next to me during the entire hearing. And so they were testifying about him and all the parents of the school was, and all of his deficiencies and issues. And he was hearing all this stuff. And so he wrote articles on our website. What it was like to sit next to Pete Wright while he's cross-examining all my teachers and everything. It's pretty cool. It was a lot of fun for any. So bottom line though is I go through the entire file and see what really, my perspective, what is needed, not so much what the parent wants. And as I said, probably half the parents were going in the wrong direction. And of course they thought they were going in the right direction, or they were going for something that really wasn't worth their while when there's something else that was much more important. So first thing, go through the file. Second part of that process then is anytime the kid had an evaluation of any test of any kind, the Wrightslaw, the Woodcock, or expressive speech, whatever else it might be, I always flagged that on the evaluations and on the file. Then I went back to the file a second time, and I would actually take a sheet of paper, a bunch of paper, and log in the testing, the dates, what the particular tests were. So then I had a list that the youngster had been given the Woodcock Johnson 4 times over the span of 12 years or 13 years or 15 years. So, and then I would go through the test data and I would look for every test that's been repeated at least once. In other words, where we had at least 2 of that same test. And I would search for the date of first testing, the scores were, and by then I knew what to be looking for. Was it expressive speech? Was it written language skills? Did it have to do with math? Where was the kid's greatest weakness, greatest disability, and what needed to be strengthened? And I would take those areas and look for the scores, look for at least 2 of the same test. And I would start making a chart of the scores. I would log the scores, the standard scores and the percentile ranks, the subtest scores, log them in on a sheet of paper. And then I had a whole thing in front of me where the kid was going up, showing progress, where the kid was flat, not going up and not going down, but more important, where the kid was regressing, where the scores were going downhill steadily each time. And for the program yesterday on the past few days, I used an example of a case that I had many years ago. where the school system gave the wood cup 4 times. And you convert the scores from standard scores to percentile ranks. And the scores went downhill just like this steadily, and made them into a bar graph. And the reading just plummeted. And as an attorney, and especially due process litigation, I always saw my role is to try to make the case easy to understand, so that a lay person who doesn't know the difference between autism, dyslexia, and cerebral palsy, a lay person could see this wasn't good. This kid was damaged. That was how I tried to make my case, so that it was so easy to understand. And I had to prove that the public schools program was not appropriate in a tuition private school case. I had to also prove that the private school program is appropriate. So I didn't put my cases on that way. I didn't try to attack the public schools IEP as not appropriate. I didn't use that word appropriate. Instead, I had the reading scores going down like that. The program that they use damaged the child. And here's the proof from their own testing. Their own testing is the proof and the evidence that the kid was damaged. That was simply by trying it before. And it jumps out at you. So the second part, in terms of preparing, you have to file organized, chronological order. When you do it in chronological order, it starts to tell a story, as opposed to looking at a little snapshot of time for the past 6 months or the past year. You have to be careful about zeroing in on present circumstances, even though that's what's driving the parent into the office. So then we have the whole story. You can kind of start to develop what's the theme of the case. And for me, the theme on this other one that I was talking about was their own testing. 4 times they tested this kid, and every time reading scores just plummeted steadily downhill. So a very simple thing, visual imagery with a bar graph showing scores going downhill. A layperson can understand that this, whatever it is they're doing, is not working, it's not appropriate. So that's the second part of preparing for an IEP meeting. And I did not go to the IEP meetings. Many special ed attorneys do go to IEP meetings, and it works out very well. For me, I really found that I felt my role was to empower the parent to be able to handle the IEP meeting on their own without me being there and without me being their spokesperson. And for fully probably half the cases that I got involved in, school system never knew I was involved. I told parents, don't share it with anyone that I am working with you. And this is our goal, but you don't share it, because it's going to get out there, and the school district learns that I'm working with you, they're going to bring their school board attorney in right away. And all of a sudden the wagons will go in a circle, and they're going to gear up for litigation. And we don't want to have to litigate. We want them to provide this service themselves, what's needed, willingly. Because if they do it willingly, rather than a gunpoint or a court order, the quality will be much, much better. Because we try to structure it so it's their idea if the kid needs this and needs that. But parents got to be shrewd to get to that level. So it's almost about sales and marketing. I tell parents, it's not the law, it's not the facts. It's all about marketing and sales and how you present. So I had my parents, and also when Pam and I taught special ed law, we were married, my law students, they had to read 2 books. One was called Getting to Yes. Getting to Yes is all about negotiation skills. Just when you're negotiating of buying a car, buying a house, or any complex scenario, when you master negotiation skills and really understand it, you are able to talk to the person on the other side of the table and say, now, I understand what you are afraid of if you give me what I want is X, Y, and Z. And if you are correct, if that's exactly what they're afraid of, and then you shift over and you go through there's about 4 elements you have to express to them about what your fear is this, and so forth. You go through this, and when you do it and you're right, you did tap in to their mindset. Oh my gosh, she understands. when they feel, the opposition feels that you understand their position, but you don't agree, all the polarization and anger goes down. Because they understand, we don't agree, but we understand each other. And when that happens, it changes psychological dynamics significantly. When they're not motivated because of anger, and you're not motivated because of anger and revenge, the odds for successful settlement jump sky high. However, I've told my parents, we have to assume that we are going to go to litigation. We're going to have to assume we're going to a special education due process hearing. And you have to assume that you will not be able to testify. I don't know what I told my parents, and it got worse. So we are going to go to trial, and you can't testify at your own trial. And if we win at due process, they're going to appeal it to the U.S. District Court. And if we win at the U.S. District Court, they're going to appeal it to the U.S. Court of Appeals for the Fourth Circuit. So guess what? This is not going to be something resolved in the next week, next month. This is going to be a long haul process, because we have to prepare the case for the district court and the Court of Appeals now, and you can't testify. Wow, so that's really putting a heavy burden on the parent. Well, how can I get into evidence? How do we prove this? How do we prove that? First, one, using their documents to prove our case as much as you can. You'd be amazed how the treasure trove of information is in there. Second, by your paper trail, all the letters and the emails you write, that document this, document that. So that becomes, because it's very hard if you have a letter, a nice formal letter to the stranger that blocks something up. It's very hard for a school board attorney to cross-examine a letter. But it goes into evidence. We have it as one of our exhibits. The Bureau testify out with the letter. So having a paper trail by your writing things builds the case significantly. Because then it can't be denied that they said this. If you made it real clear, this is what I've heard. If I misunderstood what you said, please let me know. Otherwise, it's not necessary to respond. Well, guess what? They're not going to respond. They don't want to respond. So for critical things, you always say something such as, I hope I really understood everything correctly, because this is what I've heard, and this is what I think you were telling me. But if I'm confused, if I'm wrong, please let me know. But if this is correct, then fine. I don't need a reply. Because they don't want to reply, so they won't, most of the time. Then something happens down the road, that comes out. That's the thing that can easily nail them. So you have this whole paper trail, and you're building your case from that. And then I always had expert witness. So I had somebody who would come in and go through the data, and many times, like the North Carolina case, had actually ended up having two, and the parent was able to get them into the 8th grade classroom where he had an aide before the end of the school year, because those two people, one was a psychologist and the other was an educational expert. They were evaluate James and share the evaluation results with the school as to what could be done with regard to his educational program. And so they opened the doors for them to come in and eyeball it. So I got observations of the program for them to be able to testify as to how the program was bad, damaged the kid. So which is where I want to be sure I'm kind of get going in the right direction for you all. The preparation for the IEP meeting is getting your file together, getting your test scores together, being sure you really know what your objective is at this IEP meeting. And get the thing up and running now. Okay, great. All right, well, I have some slides. I've told you a lot of this already, and then I've got a PDF file that I'm going to open up, hopefully. So let's see. Okay, this is the book. We've written a bunch of books, especially, I don't know, this is our promotions for advocacy book. This is considered the Bible. I tell parents they have to read it 3 times. The first time a parent reads this book is because when a parent reads this book, they will have flashbacks to things that happened in their relationship with the school staff and get kind of upset as they relive an event and feel like, oh my gosh, if I just done it this way instead of that way, this wouldn't have happened. So it's an emotional roller coaster for parents on the first read. So I tell parents the first time you read this, do not highlight, do not write notes in the margin, just read it. Ride the roller coaster. Your second read, then you can go back and highlight critical parts and write notes in the margin. Then your third read is really a skim of your highlighting notes and your the highlighted portions of the book and what's notes you have written to yourself. So chapter 9 is all about organization of the file, how to do it. And I've also got a YouTube video on it. That's what it looks like there, the YouTube video on chapter 9, but it's up on YouTube. So you get the file from everywhere, and we have sample letters in the book and the YouTube video, get everything sorted. Now, and you want to have stuff specific to the child, but don't fill it up with information about autism or ABA. I mean, that's not specific to your child. Just have it specific to your child. And don't put all the homework stuff in there, all the quizzes and the classroom tests, but don't throw them away. Because I have found so many times old homework assignments or teachers' comments get written to the kid later on can be very powerful evidence down the road. But initially on they may not be, but don't throw them away, because I have found that to be very helpful at times. Date everything in the lower right-hand corner with a pencil very gently. Because if we do go to litigation, you're gonna have to erase the dates. You're gonna have to erase that date. And we're gonna put exhibit markers on it and everything else. So you do it very, very gently, but only in the lower right-hand corner. And if the document is landscape IEP, for example, as many documents are, landscape IEP, you still turn it vertical portrait. And then in the lower right-hand corner, vertical portrait, because you're gonna have all your documents in that kind of a format initially. And never write, mark, or highlight an original document. Leave it totally protected, leave it clean. And don't ever take your file. Let's say you're going to see a psychologist, an educational diagnostician, a therapist, a tutor, whatever else. Don't leave your master, ever, never, never. Offer to make copies or whatever else it might be. Now, if you feel really compelled and you really want to write on this document about how so-and-so was all wrong when they wrote this sentence, don't highlight it, don't mark it, make it a Post-it note. You can do that. But you want to have it set up so that you can still photocopy the entire document or scan the entire document. And then when you have it like that, makes it very easy. You can just put it on a memory stick if you're having contact with private evaluators or tutors or whatever it might be. And we talk about that at page 70 in the book. And when the parent has done this, and it's not an easy task. It's not easy at all. It does take a while, because what happens is the parent gets so distracted as they're going through this. Oh my God, I forgot all about this 6 years ago. Look at what they did. And so all of a sudden, all these emotions will come back too. You get flooded with stuff, and you say, now let me see what happened to that. And then you shift over sideways and get distracted on something else. And so it is a difficult process, and it's even difficult for me when I ended up doing it. But when the parent gets it organized like this, and then they go into the meetings, and the file is neat, well organized in chronological order, they do feel you can see the whole change. They feel like I have some control. They're more confident. They are in control. And when the school district has a triennial. Now, am I out of the camera? Do I need to stay put over here for the camera? I do. Okay. I'm so used to walking around.
I'll move it for you.
Well, no, I'd say that's right. Then I'll get even more distracted if I may say. I just apologize for that, folks. As I forget that we're doing a Zoom also. So for you all out there in the other world, tough. Yeah, you can't be here, but we're glad you're here now. At any rate, lost. Okay. When the parent has a file nice, neat, well organized, and they're going to a triennial, and there was a new evaluation done by the school psychologist, And Mrs. Smith, we were planning to get this to you before the meeting, but it didn't come out. We had problems with the computer, and we couldn't get it printed. And so, but we'll have a copy for you at the meeting. And the parent doesn't want to push the meeting date back any further, so they can get it ahead of time. They just go ahead and go on to the meeting. They're given this report. Now, what my parents were able to do was they would be given this new evaluation. They would skim through it very quickly, jump to the last page, where many times that last page or the last few pages will have all the test data. So they'll skim through that and look at the tests that were given. At that time, they'll recognize several that were given to the child previously in time. And they remember, oh, here's the woodcock. They gave him the full woodcock. And I know they did that at least twice before. The parent quickly checks their own list, because they've got a list of all the documents, and they have this date of woodcock and that date. Then their file is neat, well organized. They reach down, they pull that out, the file, they take out the two documents of testing that was done before, several years before. Then they take out a blank sheet of paper and they lay it in front of them on a table, landscape horizontal, and they do a freehand drawing of the bell curve. My parents learned how to do this. Our law students learned how to do that. And some of the students the past couple of days have learned how to do it. Do a freehand drawing of the bell curve, and putting in standard deviations, subtest scores, percentile ranks. And then they didn't look at the new evaluation. Instead, they went back to the old first evaluation, looked up the critical scores that were the issue with the child now, and logged in those scores on the bell curve that they just did. Then they went to the second evaluation that was done just 2 years ago, we'll say, and logged in those scores. Then they turned to the new evaluation and log in those scores, and they know right away, because it was measuring the same thing each time. They know right away whether the scores went up, stayed the same, or went downhill. And so many times I found the scores went downhill. And when the school staff said, as the parent was doing it, well, what are you doing, Mr. Smith, with that piece of paper? I don't understand what you're doing. I'm trying to measure the progress for my son. He was here 3 years ago. Last year he was here, and now it's down to here. This is concerning. Oh, we don't do it that way here. We're using the XYZ series in terms of teaching your son how to read, and they provide us with these various ways to measure progress over time. And we are feeling so good about the progress your son is making. He's gone from level 5 to level 7 just in the past few months. So I think you should feel really pleased about the improvement that he has made, the progress. And because we feel good about it, and we need your support with him. He needs to know that you support us in what we're doing, because it's been great progress. Oh, level 5 to level 7. And this shows he's gone downhill. I must have done something wrong. I must have made a mistake on this. I am so sorry, but I don't understand it. I'm so confused. It's so hard trying to just stay on top of what's going on with my son. And I just don't know. Now, she does know. And she knows he went downhill. And she knows level 5, level 7 means diddly squat if it gets worse over time. But she's not going to hit him in the face with it. But she's smart. She's shrewd. She read the Promotions Advocacy book. She read the Getting to Yes book. Okay. And she knows it's marketing and sales. So she kind of just goes limp, because what happens is after the meeting, the school psychologist that did that testing gets together with, let's say, the director of special ed, a couple other people. Let's look at those other earlier tests that she had out. Let's see. Oh my God, he has gone downhill. They will arrive at that without her hitting them in the head with it. We got to make some changes. And I tell Mom, you're going to get a call probably within the week about wanting to make a shift in his IEP and change the program they're using with reading. Happened to them every time. But the parent had to play dumb and stupid. But they made the change on their own, not the parent telling them you had to make the change. That increased the odds it would be successful and would work. So getting into preparation for the meeting, file organized, understand the test scores, know exactly what the issue is in terms of what your kid needs, what you want, and how to get there. Now I'm gonna see if I can shift over to something else in a second here. Let me give this a try. And that's the bell curve right here that my parents could draw and they would log in everything. And that's chapter 10 and 11 in the From Emotions to Advocacy book. And that's the same data as the bell curve. You find the same test that's been given over time, complete the changes. And that's an example of one that I used the other day. This is a live case that I had. The kid went from a 97 percentile rank in reading down to 78. And that looks like 97, that's right around the middle, mean 150th percentile rank. It's actually 42nd percentile rank. His IQ was above 130. And those years, back there in the 90s, they used the discrepancy formula to determine whether a child did or did not have a learning disability. So they found him eligible for special education because of a learning disability in reading, even though it was a 97, 42nd percent. And for the trial, I charted out the scores. I converted these standard scores, these are standard scores, to percentile ranks. And then I made a bar graph of the percentile ranks look like that. That doesn't market and sell very well. That doesn't hit you in the gut. The kid was damaged. And my theme was the kid was damaged by their program and their test scores proved it. But this doesn't do that. I then converted from standard scores to percentile ranks. And again, this, you can see a decline there, but still it doesn't market and sell. I then changed the colors. All I did was change the colors. Again, marketing and sales, changing the colors. Red's the power color. Then I took that embedded Excel sheet. So I had the scores and I had 4 rows. Open that up, double click on the file and it opens up the Excel, and I deleted all of the rows except for reading. Your Honor, he went into the special education program because he had a learning disability in reading. They tested him quite a few times between January of 90 and June of 1995. And this is what their testing proved happened. This hit the hearing officer between the eyes. Clear evidence of damage. Again, I didn't argue not appropriate, I argued damage. And this being the theme, the writing went up and down. Turned out the parent had hired a tutor to work with him, private sector from the school where he was placed presently. And then this is what happened with his arithmetic. So basically visual imagery, a simple theme. And that's what kind of causes a change to take place. In our All About IEPs book, there's a whole thing in there about preparing for IEP meetings. In the book, y'all don't have this book most of the times when I do my training. All the attendees will have 3 of our books: the law book, the From Emotions Advocacy book, and this book. And question 20 on page 24, there was a question about a parent wants to consent to just one thing, but not anything else. And is that acceptable? And we explain right there in the book that the agency may not use refusal to consent to one service as a basis to deny others. We have in the book, this is the IEP book, the 5 rules for successful IEP meetings. And so be sure you know exactly what you want. Be clear about it. We had in the session earlier today, a person asked a question about not being able to find an attorney, and might be here in the room. The one that had the question about that, where they couldn't find an attorney, but the parent wanted, I think it was somebody up in the Northwest states of Washington. Is that person here in the room right now? I was gonna, where we had the parent wanted apology or wanted quite a few hundred hours compensatory service. Okay, it's not. Well, at any rate, the issue had to do with the parent wanting a school district to apologize for how they dropped the ball. But then in the alternative also wanted comp ed. Wait a minute now, one or the other, in other words, it was not clear as I was trying to flush out the basis for the question from that person, where the parent, and they were just working with the parent, where they were really going. And well, they were going this way, but then maybe this way. And it's gotta be locked up tight and clear and specific and a basis for it. Now, parents know that they can never blame or criticize. You don't go into meetings and attack, blame, or criticize. My parents had to change their persona when they were dealing with school officials. They had to become a merged personality of Mrs. Manners, Peter Falk Columbo, with a touch of Mother Teresa. I mean, literally, they did, and I would drill them on that. So my parents, when they were, I was a taskmaster, they would come in to see me, and sometimes, let's say, third or fourth face-to-face interview consult, I'd hand them a blank sheet of paper, say, I want you to draw the bell curve, and I'm going to give you some scores to log in just a moment. I gave them a blank sheet of paper, and they had to do a freehand drawing of the bell curve. Now, there was another book also that I had my parents read, and that is How to Argue and Win Every Time, but it's not about arguing, not about winning. It's about how to negotiate where you have issues like criminal defense cases. The author of the book, Jerry Spence. Jerry Spence is probably the best criminal defense lawyer alive today. If you were to Wikipedia him, it explains he has never lost a criminal defense jury trial. Never. How does he accomplish this? Because he, in the process of his doing direct exam and also cross-examination, he tells a story using visual imagery that causes the person, the opposition on the other side of the table, to feel the pain in their gut. And from there, it rises up to the heart. And when they feel the pain of that person in their gut and in their heart, it then controls intellect and their decision making. So the job is to get the jury, or for my parents, to get the hearing officer, the director of special ed, to understand, to feel the pain in their gut, then in their heart, and that will determine what direction and how they're going to go. So that's what his book is all about that concept, and it's superb. So you don't ever blame or criticize. You seek win-win solutions, and you got to understand the school's position. And if a parent really understands and the basis behind it, and the school knows the parent understands, then you're on the way to getting things resolved. And then in chapter 2 in our All About IEPs book, we go into some depth about the members of the team and getting advanced drafts of it. And then chapter 3, scheduling, consent, and more. So in chapter 7 is all about behavior and discipline issues, behavior problems, FBAs, behavioral intervention plans. And on our website, if you were to go into our website and simply put in the words FBA in a search engine, you'll find all kinds of stuff, for BIP. You'll find all kinds of stuff in there. And the book is a frequently asked questions book, so it's filled with all kinds of questions. Now, I can't do this on this computer here. If I was using my own, I would be able to show you some additional things, because for example, how to find cases in Google Scholar, and also when you find cases that have come down, how to open up the court's file, the U.S. District Court file, or the U.S. Court of Appeals file, using what's called PACER. And that's all. We have another book out, our third edition special ed law book, and that's all explained in that book on how to do all that. And I think we have gone beyond where I'm at the end now. So very good. I will now give over and give my microphone to others. Should I? Where's Marty? With Marty? No, he's not there. Okay. I guess any questions at all?
If you look at the slide right before chapter 1, where looked like you were saying parents can choose. I think we'll tell you that 3, 1 slide before, that's 1 right before that. Please, sir.
Yes.
Agency may not use refusal consent to one service as a base. That was the question I had for you, sir, today, and I didn't have to ask it.
Oh, in the earlier training earlier.
There, but I
Oh, it's on page 24, and All About IEP's book.
thought I was footnote 99 in your education law, but
Good for you. You know our books better than I do.
that. and I can't find chapter 89 that says they can.
I don't think there's any dispute about what the law says.
True.
So, you know, it really should be a non-issue. And so,
I have to say, I've asked TOPA, and TOPA members, I don't know who it was, said Texas will not allow that, so they won't even hear it at a TEA complaint, so I haven't even pushed it anymore.
well, if it's, if it's not in writing as a formal complaint, complaint never came in. In other words, you're gonna have to have clear documentation, and if you can if you can make it a state issue, if you can make it real clear, it's the SEA that's doing this, driving this, for telling school districts to do it this way, then as a single defendant, it's easier rather than trying to go after this district or that district and have everything flip. So I would go straight after them. That's what I would attack, and find out who's doing it and their authority, flush out their legal authority and the basis for doing that. And here's the regulation right there, 300D3. Question?
Or you have to reject sped in its entirety.
And that's absolutely incorrect. And there's other case law out there.
Right.
This is consistent with this.
Because you've been doing this so long, do you think some of these OSEP letters and guidance letters that they're rescinding and, you know, all the guidance that we've gotten that sort of clarifies some of the federal law or helps understand it? What, can you tell me a little bit about that? How do you always tell people
I never really put much weight on those letters, even when they supported my position, because that's nothing more than one person's opinion or the opinions of several upstairs in this central office or in DC, opinion about what a statute says. Okay, now the Department of Ed writes the regs, but if the reg isn't totally consistent with the statute, then there's questions about the legitimacy of the reg. And there have been some cases that have come out, not in special ed, but in other areas, where there is questions are raised about what authority a regulation has if it's not consistent with the statute. And so again, as personal opinion, so as a lawyer, I didn't use those things really so much as my legal authority. The logic and the explanation is what I would use. Okay. Slight difference, okay, but not that as the basis. Instead, the logic behind it, and now here the regulation though is very clear, and that's the position of the Department of Education, this U.S. Department of Education. So I would still go out to Texas on this and try to fit. Well, I'll give you an example. I had a case where I won at due process. School district did not implement the decision, refused to implement it. I pushed them to do it. They said, we haven't decided yet whether we're going to appeal. And in Virginia at that time, it was either 1 year or 2 years. It was in earlier years. And I then contacted the state and said, I want you to force them to implement. So we will do that. I thought I had the state on my side. And so I was going to use the state because I want the state to jump on the school district. But then they backed off. They said, well, they're thinking about appealing, so we're not going to. So then I said to the state, said, well, you're the ones charged with responsibility for enforcing this law. I've already won at the lower level, so I'm going to sue you for the tuition reimbursement and prospective future tuition at the school. I'm going to sue you, the state. Oh, you can't do that. No, your case is against so-and-so county. But I've already won against so-and-so county, and you're charged with enforcement of this. Oh, no, we don't do that. You can have to wait and see if they appeal or not. So then I contact U.S. Department of Education. I said, I want you to go after Virginia because I had it all documented. I mean, I had a whole beautiful paper trail. So I went after the Department of Ed, and their attorney got back with me on it and said, they are in the wrong, and we will contact Virginia and try to force it. Then they did, and then they backed off. So, well, the school district might appeal, so we're not going to do that. I said, okay, well, now I'm going to sue not only Virginia, but I'm going to sue you too. You have now, oh no, we don't want to be a party. We don't want to be involved in this, Mr. Wright. We're not in the case. We're on the sidelines. I said, you either get on my side of the playing field or their side, but you're in it, like it or not, one way or the other. You're going to be a defendant or you're going to be a plaintiff with me. because I'm going after Virginia, and after I sue them, if you don't jump in, I'm going to join you as a defendant. You can't do that. I said, well, watch me. And I did. And they backed off and they went after Virginia, but I didn't make them a plaintiff. They pressured Virginia real hard, but we still went to federal court. And the U.S. District Court judge made Virginia Department of Education pay private school tuition. And perspective too. But so, you know, you can't go after these bureaucratic entities, whether it's state or federal. And so that's what I would try to do. But you got to make it a clean, simple issue.